3 jurors jumped up like you did when I told you. They stood up and, what? And then...
So he said he rolled through the stop sign again.
He rolled through the stop sign.
After killing 2 little kids.
4 people. All 4 got killed.
Why would he say that? All right, everybody, welcome to today's episode of Cases Gone Wild. We have a very exciting episode for you today. It's going to be jam-packed with some of the craziest, wildest stories that you've ever heard from the law, from the legend. We have an OG legendary lawyer today. We have Sheldon Miller with us, who I'm going to introduce. Great lawyer, great guy, great friend. I'm Jon Marko. Welcome to Cases Gone Wild. I've seen some of the craziest cases that you've ever seen during my career, and I bring in lawyers who talk about some of the craziest cases they've ever seen. If you like the show, please subscribe, leave us a review, share it with your friends and family. Remember, this is being videotaped and you can see the video live on YouTube, on our YouTube station, or you can listen on your favorite Audible or Spotify, all the good podcast options for you there. On today's episode, I'd like to introduce Sheldon Miller. Shell, thanks for being on the show, buddy.
My pleasure, John.
Shell is an OG, okay? He graduated from Wayne State Law School in 1961. He served in the Army during the Korean War. He used to be, you were in the golden era, kind of, Shell, of plaintiff's law.
I and my firm helped make it the golden era.
You did, man. I understand you used to have a limo. You used to roll around in a limo.
Yes.
You had a plane for your firm.
Yes.
You've had townhouses and properties all over. You had New York, and I understand Florida and everywhere else.
I had a great partner, and yes.
Those were the days, man. So hopefully we're going to bring them back. I have here too. You were the former president of the Michigan's Trial Lawyers Association, which is now called Michigan Association of Justice.
True.
And weren't you also active in the National Association of Trial Lawyers of America?
I was vice president of the national organization and on their board of governors for 32 years. It's a 3-year term. I kept getting reelected, and I finally stepped aside.
And I was reading a book the other day, and you're on the first page. This is... it's called The $1 Million Lawyers book that I'm showing here. And it's about some of the best. It's by Joseph C. Golden. And it's like the top lawyers around the world. And you're in the prologue. I'll read it. It says, "A bitterly cold January afternoon, I stomped my boots on the foyer floor to shake off the encrusted snow and stepped into the brick 100-year-old townhouse on Jefferson Street in Detroit, leaving behind me on the street the near-zero winds whipping across the Detroit River. Lawyers all over the Midwest had been telling me, quote, if you want to see a collection of tough, honest cookies who are driving the insurance lawyers batty, go see these guys in Detroit." And he was talking about you.
Yeah.
That's pretty good. Well, I'm guessing, Shell, having this experience, how many cases have you tried?
Who knows? I started off in what they called common pleas doing property damage claims. You could try 2 of those cases a day. And I was. I mean, it took 3-4 years till you got into personal injuries. I got in there after about my 2nd year doing it. But yeah, we were trying a crap load of cases.
And you're still practicing. I still see you in court. You're still trying cases. I have the honor of working with you on a couple cases together that we're teaming up on.
Yep. I'm proud to have you or me be with you.
I'm proud to be with you, Shell. And I know you worked with some other great lawyers throughout the years. I know that you did trials with Jeffrey Feiger, with some other very prominent and famous lawyers. And you've told me some of your stories. I'll tell you your Picasso story. I thought that was Jeff's. When you compare the value of a Picasso, you do it better than I do. Why don't you tell our listeners?
Well, you got to get to it, but okay. First of all, when you mentioned Jeffrey, when he started practicing, he brought me in to try cases with him. He learned from me, okay? And I'm not saying he didn't achieve greatness. He did.
Yeah.
But at the very beginning, I tried almost all his cases with him. In fact, he got to Jack Kevorkian because of me. Now, not on purpose, but you want to hear that story?
Sure.
Jeffrey had a malpractice case against a hospital and a doctor. He settled with the doctor and went to trial against the hospital. Now, under the rules, the hospital would get a credit for how much the doctor paid. You can't collect twice on the damages. So he tried the case against the hospital and got a very nice verdict, way more than the doctor had settled for. The hospital then filed a motion in front of the trial judge who reduced the verdict. So Jeffrey appealed and ultimately went to the Supreme Court, who reinstated the original verdict. So he waited until the time passed, clever, where nobody could say anything, and he went back to the hospital and said, I want the amount of the verdict. And they said, well, we want a credit for what the doctor paid. And he said, sorry, my verdict from the Supreme Court reinstated the whole verdict. Go to hell. So they said, well, we're not going to pay. So he called me. What do you think I should do? This was not an original idea for me, but I got it from my first employer, who told me that he once had a case where he got a verdict against the workers' comp people, and they refused to pay it. But he had a judgment, a final judgment, and he went in on a Friday and with a sheriff and picked up their typewriters.
No, so he got a judgment and went to the workers' comp company?
Went to the employers.
The employer's company
And with a sheriff and picked up, with a sheriff those days we didn't have computers. He picked up their typewriters and they paid. So I told that story to Jeffrey. I said, go into the hospital and pick up their x-ray machines. Well, being Jeffrey, if I said x-ray, he'd pick up something else. He just wouldn't do that. But he went into the hospital and was picking up something on a Friday afternoon.
With moving trucks or what?
Whatever it was. I wasn't there, but I know the story. And they paid. They
paid
stopped,
real quick. Yeah, this is a famous story. I heard about this growing up. He took the judgment, got the moving trucks, moved to the hospital with a bunch of movers, and said, I can start collecting your assets. Right. Give me all your x-ray machines or whatever it was.
Right. And so they paid, and Dr. Kevorkian read that story and said, that's the lawyer I want to represent me. And that's how Jeffrey got together with Kevorkian.
That is crazy. Now, you helped me. I just did a trial up north, and thank you for helping me, because you have such great strategy on this, and you helped me simplify and work on my opening so I could get a better kind of get into it quicker, right? Get into it and convey it.
Opening line is the biggest thing you do in a case. First question on cross-examination. You want to hit them with a bang, get their attention. And the opening is, a lot of lawyers make the mistake, if they haven't gone to these colleges where they learn, they like to say their name first. That's a wasted opportunity. You want to hit them with a summary that'll get their attention to make sure they're going to pay attention to the rest of it. And that's what you did, and you got a great verdict.
Yeah, thank you very much. Thank you very much, Shal. So tell me, okay, in such a legendary career as yours, having tried so many cases, probably more than anyone in the bar right now.
Well, not that many people are still practicing 60 years later. Most of them are dead.
Nonetheless, Shal, I bet in those years you have had truly cases gone wild that are unimaginable.
Yes. And as you were talking about the golden age, some of the cases that I tried brought us into the golden age. And one of the stories I told you that you wanted me to talk about was a change in the law, getting us from the archaic way trials went and what the law was into the new age. And I was the first one to try one of these cases in a new age. and the result was
The rest is history, they say.
the rest is history.
Well, why don't you tell us about it? So what was the case about? What happened?
Okay. Starting with, it took place in Brighton.
Brighton, Michigan. Okay.
Brighton, Michigan. And it was filed by my office in Wayne County, which it shouldn't have been. But the reason, and the defense lawyers could have transferred it to Brighton, but just to show you what was going on, the two defense lawyers who came in both had their offices in downtown Detroit and figured they weren't going to lose that case, so why should they travel to Brighton? So they left it in Wayne County.
So Brighton is in what county?
Livingston.
Is it Livingston County? Okay.
Yeah.
So
Okay.
for our listeners, normally if there's like an auto accident case or whatever, there's certain exceptions, but you have to go to the court where the accident occurred.
Correct.
So if it happened in Livingston County, you got to go to the Livingston County courthouse.
Right.
Happens in Wayne County, you go to Wayne, and so on and so forth. So all right, so you're in Wayne County, which is the best
Detroit.
county for us, right? I love Wayne County.
But it gives you an idea of how little the defense lawyers thought of it at the time.
So they thought this case sucks so much, we might as well just leave it in Wayne County so we don't have to travel far.
Right. Because here's what the law was. We start with Michigan started off with the common law coming from England, okay? And in England, the common law was there were no lawsuits for wrongful death, okay?
Which to me was crazy. So if you kill someone, you don't have to, they can't sue you. But
Right.
if you just, maim them, then you can't.
Right.
That's crazy.
It was crazy. But we were a little more civilized, not that much. And so a law was passed to allow them. But keep in mind that the powers in the state were not the victims, but the big-time lawyers who represented corporations and insurance companies. They had the money, they had everything. And so the laws that passed, the law that was in Michigan said you could get pecuniary damages.
Now, what does that mean?
Money. Whatever your money loss was, that's what you could recover.
Well, what do you mean money loss? Like, does that mean like pain and suffering? Like if you get dragged under a bus or something?
No, nothing.
Well, what if you're poor and you don't have anybody?
You got your hospital bills, lost wages, if you suffered. But the main thing for children, which is what I'm going to talk about, was the funeral bill.
That was it?
That was it.
So let's say that you're like disabled and can't work. You get killed by a truck. All you get is your funeral bill and hospital bill?
Yeah.
That's horrible.
Yeah, it was. And in 1959, the Michigan Supreme Court, way ahead of a lot of other states, decided in a case that pecuniary loss included loss of love, care, and affection. They were a Democratic court by that time.
Okay.
That was 59. In 69, the court had changed and we had some Republicans, Tom Brennan, Jim Ryan, and they said, and they were right for once, they said that pecuniary means money damages. No, and it's wrong for this. But they added this clause. They said, if the legislature had intended to give damages for loss of love, care, and affection, they would have said so. And guess what? The Michigan legislature immediately changed the law to include loss of love, care, and affection. So now everybody was at a loss. What is the law going to be? What the Supreme Court had said before the legislation? Or was it going to be the new legislation? And so everybody waited. And the case that I had was one that was waiting to see what the ultimate result was. To the credit of the Michigan Supreme Court, they then said, well, we said if the legislature intended it, and they did, so we were wrong. And
Right.
So now these cases that had been waiting to get the decision, we're going to go to trial under loss of love, care, and affection.
Which is a big deal because in your case, for example, like who was the injured person? Like, was it a child or?
I had two kids, one 10, one 12.
And did they die?
Yeah, they got killed in an accident.
So before this law, it would have been crazy. They would have gotten a funeral bill
Period.
and whatever, the
Period.
Undertaker or whatever bill, whatever
Yeah,
maybe.
yeah, that was it.
That's horrible.
That's why the defense lawyers didn't care.
Yeah.
Okay?
That's why they didn't care.
Yeah, they didn't care. Even though they were senior partners in their firm, they didn't care.
So
Okay.
what happened? So in this case, so how did you test it?
Well, here's what I didn't test it. It had already been tested. Okay, we had been waiting for the test, and the test now came out and said you can get loss of love, care, and affection. Well, I had no experience in trying a case where the children were there because they're technically financially they're a liability. They cost more than anything.
Yeah, I
okay?
know. Trust me, I got 2 kids. They cost.
Yeah, I know. So now, when before you would try, you'd have a case, you'd have a father or mother, whatever it was, they had losses. Here, you were doing with people who financially, and I hate to say it, but financially, they were better off. It's as stupid as it sounds, but it's true. And so we were going to go into loss of love, care, and affection. And so we had to start. So let me tell you how the accident took place, okay? What happens is in Brighton, there was I call it a mountain, a big hill, 200 yards up from the bottom, maybe a little higher than that. At the bottom of the hill was a pit, an aggregates where trucks were taking big stones out in double tandem trucks.
Like a gravel pit type
It was
thing?
called American Aggregates, yeah. And they had these double tandems, and they were 90 degrees from the road that was coming down this hill that was a couple hundred yards down.
So there's like a road that went up and down this hill.
Yeah. Okay. And these trucks would come out from the bottom of the hill, and they'd have to turn up to go up the hill with these big trucks loaded with rocks, okay? And they would go slow, real slow. And they would run the stop street frequently.
What do you mean run the stop street?
They put up sign. First, originally, they had one stop sign for them, and they didn't stop then. The state police came, and they screamed at them. So they put up a stop sign on each side of the roads because they were looking to go up on their left, and so they put a stop sign on the left side,
so
too.
the trucks would have to stop to make it safe.
Yeah, supposedly. Okay. And on this day, the kids had stayed after school to play basketball with their neighbors. So there were 3 kids, and the neighbor's father picked up the kids and was taking them to their home after school. So they were in a pickup truck, an older pickup truck, coming down the hill when this double tandem truck pulled out of the road. They smashed into it, and all 4 of them got killed.
So the truck just like pulled out.
Never stopped.
And ran a stop sign essentially?
2 stop signs. Yeah.
Ran 2 stop signs and crashed, killing these kids.
Yeah, well, we crashed into the vehicle that was blocking the road.
Okay.
Fortunately, so the only eyewitness to it was the truck driver. But
because everybody died in the pickup?
Yeah, there were no eyewitnesses. But obviously, it was a horrible accident. And the state police, there was a state police lieutenant who did the investigation. He did a fabulous job, considering everything. Of course, 4 people were killed. He did ecstatic measurements on everything. I knew how far the road was from the top of the hill. I knew where the driver was. He admitted he didn't stop. When he said he looked and didn't see anything coming down the hill, and so he thought he could pull out safely. We had all the measurements. He was in 4th gear going 6 miles an hour, okay, which is, in case you don't do that kind of work, it's about 9 feet a second, okay? And our truck was 200 yards up the hill, blah, blah, blah. I did all the measurements. I felt pretty secure on liability, because the one thing I could trap this guy on was, according to his measurements, our vehicle had to be going at least 100 miles an hour down this hill.
Which didn't happen.
So that was where I knew I would catch him. But he was a very sympathetic guy. Keep in mind, he was not a big truck driver. He was relatively short and 40 years old, and he never went back to the scene, and he had been involved, and 4 people had been killed. And
Yeah.
So, I mean, it wasn't like he was a murderer, but here he was living with this. The police made stop and walk to the spot where he said he looked. We had that measurement. We had all the measurements. And so I knew that he said what his measurements were, that it would have to be going at least 100 miles an hour. So I was pretty happy with that. Okay? So we're now going to go into the trial. And I get assigned to a judge, just to tell you when you talk about the golden age, okay? Whoever in my office did a great job. We sued American Aggregates, who had the gravel pit, because these people kept running the stop street. And of course, we sued the driver and his trucking company, okay? And so now we're getting ready to go to trial. And in those days, you almost never talked to anybody. So I had a conversation. The law had just changed. I went to the truck driver and their insurance company and tried to settle a case. I'm so smart now, right? My demand, to tell you what the world was for the two kids, $150,000.
Wow. That's crazy, because today,
Yeah,
that's
yeah,
eight-figure
Believe,
case.
believe me, I know. Okay. To show you how bad. But if you think I'm stupid, 2 defendants, 2 insurance companies, no, wouldn't come close to paying the $150,000. So we got assigned to a judge, and I had met just with the insurance company for the trucking company. And so we're talking, and he brings us in the chambers. We didn't have anything before that. And we're talking, and he says, "How much are you looking for?" And I said, $150,000. And he said, "Your case is worth $60,000. Okay, does that tell you something?
Mm-hmm.
Your case is worth $60,000 for 2 kids.
That's crazy.
Okay, now
That is crazy.
I was not exactly a starting out lawyer then. I had already been president of the Metropolitan chapter of the trial lawyers. I had already written that case evaluation rule, and I had done 10-week trial with the no-fault law, blah, blah, blah. I was, semi-star walking up the ladder. And I had an ego, okay? And I said to him, "I'd rather give you my license than settle for $60,000.
Wow. Did the judge like that?
Oh, he loved it. You know what he said? He said, "You only met with the lawyer for the trucking company. You didn't include American Aggregates lawyer. That's unethical. I'm going to just send a letter. I'm going to file a grievance against you, and I'm disqualifying myself."
What?
Honest to God.
But that's not
Honest to God.
unethical. You can talk
Of course
to one
it
defendant.
wasn't, but his ego was hurt, okay? Well, it turned out it was the best thing that ever happened to me, because now I knew that I was going to trial. They were offering $60,000 at my $150,000. Okay? So I had about a 4-day hiatus to get ready. So I really spent some time. Now, keep in mind, nobody had ever tried one of these cases. What was I going to do? So I came up with a whole plan for trying this case. The first thing that hit me was I didn't know what it was worth. So I went to a number of lawyers and asked them what they thought the case was worth.
Yeah, and that's that's one of the hardest things, is evaluating a case. Even today, I called 10 different people and asked them, how much is the case worth, right? Because some things like how much money did the person make then compared to now? That stuff's easy. But what's not is like pain and suffering, the human loss. How it's hard for a jury or even lawyers to put a value on that. You'll ask 10 different lawyers, great lawyers, what they think a case is worth. You're going to get 10 different answers.
And John, the way you are doing things, whatever the highest number they give you is what they think it's worth, you should triple it, because that's what you're going to get. That's how good you are.
I wish I could always triple it, buddy.
Well, so you double it.
Yeah.
But never take the higher. You're way better than any of the people you'll ever talk to.
I appreciate that.
Anyway, so here we are. And now I think some of the lawyers I talk to don't even want to talk about it. It's like they're superstitious. I don't want to talk about the death of a child. They think it's going to, really? Okay, don't want to talk about. Other ones say all the money in the world. I said, well, that isn't going to do me any good. How much should I ask for?
Yeah.
I couldn't get any straight answers. So I came to the conclusion that I didn't want to tell the jury how much I was going to ask for because it was all over the park. That was the first thing. And I thought about it. I say, how can I say to a jury, these lives are worth $100,000? I don't care if I said 100 million. Somebody'd say, you're putting a price on the... So that's how the Picasso painting came into being, okay? I did not want to give them a number and say, this is what I want, okay? I want to tell them what I don't want.
Right.
Okay? I also came to the conclusion that I had to come up with a dynamite opening line. Same thing we talked about a minute ago, right? 5 minutes ago. An dynamite opening line. The next thing I said I had to come up with, this was now 3 years after the kids had been killed. So the parents weren't going to come in and cry, you know. It looked almost artificial. I had to think of a couple of questions that I had never used before that would get the emotions out of the parents and legitimately, I mean, not anything that was phony, surprise them with a question that I knew would catch them off guard and really bring out their emotions. And I came out with a couple of questions like that.
And that's a good point, Shell, there is when you're preparing, right? We always want our clients to be prepared, right?
Right.
And I always work with clients, you know, like the worst thing we can have is that they appear to be liars or phonies, right? And so we always want them to be prepared, but there can be an over-prepared where it appears that it's like not natural or spontaneous, especially when you talk about like hurt and pain, right? If you go over this with your client, like in this case, the parents of these dead children, which is horrible, the most horrible thing I can imagine, the night before, and they are crying in your office and they let it all out, then the next day when you do it at trial, it's like they had that emotional outburst already. Like they're not going to do it again.
Right.
And the jury's not going to see what really went on because you did that at your office. So that's one thing sometimes we struggle with. And like in the last trial, like I had one of the attorneys who was trying to over prep the plaintiff. And I said, you know, look, I know how much this means to you. I'm going to save it and ask you about it tomorrow in front of the jury, you know, and just be honest.
Right.
And it sounds like that but that's important. What you said is you need to ask some things that they hadn't thought about or that, you know, was natural and authentic for them.
Right. And I did come up with a couple of those questions, one for each of them. And then the last thing was I sort of do my closing argument by the seat of my pants. I write down a few notes, almost no notes. And I found that in my experience up till then, that there were times in my closing argument to the jury, I'd hit a high point in the middle of the argument, and I still had things to go, and I'd say, oh, shit, I should have saved that for the end.
Yeah.
So I decided, I watch a lot of pro football with the last 2-minute warning, and I said, I want to get a standardized closing 2 minutes, no matter what happens during the day, no matter what I'm saying, it doesn't matter, till I get to the end. And the end is going to be standard. I'm going to come up with, that's the way I'm going to finish, and it's going to be a highlight. And that's where I came up with what I did. And so we went through the trial. I called the state trooper, lieutenant, fabulous witness, all the things that he went through. He had all the statements of the guy and everything else. And I had him coming down 100 miles an hour, and everybody's, well, he's bullshitting. The guy must have been closer, and he didn't see him.
Right.
So, it was fairly obvious. And so we put in our proofs. Then I put on my clients, and I started with the opening. You want to hear it?
Yeah.
Okay. The opening line kind of thing. I said, on any given Sunday, if you were to watch the Sexton family, you would see them leave church, get in their car, and drive out into the country where there are fields. And I'll come up to a place where there's grass with picket fence around it, and it's a gate, and they drive through the gate, and they drive around a part of a corner, and they stop the car, and they get out and walk over. And on the property that they're looking down on are two big stones. And the stones say, here lies Jeff Saxton, age 12. Here lies Tommy Sexton, age 10. Why those two boys are in those graves at that age is what this case is about.
Now, that's a good opening. And I got to tell you, that opening sounds almost exactly like Feiger's opening in the Jenny Jones case. I don't know if you ever saw the Jenny Jones trial. It was on Netflix about Scott Amador and how this Jenny Jones had like this like
I know who she was.
crush stuff come out, and then one of the guys murdered another person. And it was almost exactly. So I'm maybe you had an influence on Jeffrey's opening in that case.
I guarantee you, I didn't get it from him.
Okay.
Remember, I didn't realize that, but I told you I tried a lot of cases with him, but I'm not taking anything away from him.
Yeah, no, I get it. You should check this out because it sounds similar. It's on Netflix. It's called Trial by Media. But anyway, so then you go through the trial.
Yeah. Now I've got the husband or wife on, and I'm going through the things and the kids, and then I hit him with, what did you observe about your husband as you were in the funeral parlor where your friends and relatives came to pay their condolences, and in that room where the caskets were the bodies of your two kids? Picture that. And you just see them picture what they went through. And now the jury, you can talk about death of a kid, but now, why would you want to cut your eyes out rather than do that, right?
Right.
I mean, is that a visual picture? You're sitting in a room with dead kids. And to the other spouse, I said, and did you see the reaction of your spouse, whichever one it was, as they lowered the caskets into the ground? Whew! You got their emotion. They pictured that, and they just, okay. So I was very satisfied with that part of the case, okay? And then we rested on a Thursday, and I had the truck driver on, and he had said the state trooper had me stand here, and I looked where I'd done it. I had done it dozens of times, and I always saw if there was a vehicle coming down, I would stop. I had time to stop. Remember, I'm going fourth gear, 6 miles an hour, 9 feet a second. And if I saw a vehicle, I'd stop, and this time, and I'm so sorry, and I haven't been back, blah, 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 and blah, blah, blah. And we close, as far as I'm concerned. The case is over. I'd called there are no other witnesses. We come to court Monday, and I'm ready to give my closing argument. And the defendant gets up and says, we're going to call the truck driver.
Again?
Yeah, as their witness now.
What?
Totally shocked. Why? What did they do? Over the weekend, they took him back to the site. They put him in a truck, and they had him relive his drive to the road. And now he said, and they came up, I was wrong. I wasn't that close to the road. I got it wrong because I was standing there instead of on the truck. When they put me back in the truck, I realized where I looked. And so I was really 40 to 20 some feet further back. And now if you do the multiplication.
So he changed his story at the last day of trial?
Yeah.
To try to make it better for them?
Yeah. So now he was
So
now he was going 66 miles an hour instead of 100.
Were you going nuts?
Well, I was planning on making a closing. I had no idea. Suddenly, what the heck was the question? What would I do now? Okay, what was I going to ask him? Well, you could ask. Now, keep in mind, I knew just from experience that he was prepped for my question, okay? And the answer, he had already done it in straight.
His memory on the date of the incident was better than his memory years later in court?
He covered it indirect, okay? I was so shook up by what had happened. I just answered the questions. I really didn't think about it. I'm so sorry. Yes, I was wrong, but you got to understand. I mean, this was tragic to me, blah, blah, blah. Do I want him to reiterate that if I ask him about it? No, right.
So what did you ask him?
Let's take 30 seconds, John. I want the audience to think of what would they have asked him. Let's look at 30 seconds. Come up, everybody who's listening to this, what question would you ask, if any? Would you have sat down and just let it go? Would you say what John said? Is your memory any better today than it was? You're telling jury your memory's better today, 3 years later than it was 2 hours after the accident? Is that what you want the jury to believe? Is that what you would ask? I was caught off guard, so I came up with a question I will never forget. And I said to him, "Sir, when you went back to the scene that you hadn't been there in 3 years and you were driving there, and the last time you were there, you pulled out without stopping and killed 4 people. What did you do when you came to the intersection this time?" I was, in my head, it wasn't really planned. I mean, I really just did it. And you would have think he'd say, yes, and I'd say, and nobody died, right? And I'd sit down. What did he say, John? When I told you the story, you jumped out of your chair.
Tell us.
No, I said, no, you didn't stop. 3 jurors jumped up like you did when I told you. They stood up and, what? And then...
So he said he rolled through the stop sign again.
He rolled through the stop sign.
After killing 2 little kids.
4 people. All 4 got killed.
Why would he say that?
Because he didn't. Because he didn't. And now I said, and you didn't stop? And he said, now remember this meek guy up there who was also simple. Do you realize what I had to go to get this truck up the mountain over here? He says, I'm in 4th gear going 6 miles an hour. I'm already in 4th gear. It takes at least 6 gears to get the vehicle up there. I shouldn't have had to stop. I said, you think there should be... Now, what? You think there should be a special rule that truck drivers don't have to stop at stop signs? He says, yeah, do you know what I had to go through?
Oh, my gosh.
Yeah, I swayed. And then I said, well, how about red lights? He said, some red lights, too. I swear.
Was the defense attorney going nuts?
No, they didn't say a word. Are you kidding me? So that was it. You know, they didn't ask her. They wouldn't get up, and I just sat down. To show you how bad it was. Keep in mind now that the state trooper had said that these people were running it, and so he had come there and complained a number of times.
Yeah, they put in a whole nother stop sign.
So they put in a stop sign because it's normally on the right, but they're looking up to the left, so they put one on the side to make sure they didn't overlook it, so they had them both. And so here we are, and the defense lawyer for the American Aggregate said, I'll never forget this. He said, I think the only thing we could do to get him to stop is have a guard there with a machine gun.
Oh, my gosh.
That's true. And I, of course, in rebuttal, I said, no, you could have told them if they run the stop sign, they can't come back on the work site, okay, instead of all that. So
what happened? So you got a verdict, I bet.
Yes. So the jury came back for $750,000. But it was $700,000 against the truck driver and $50,000 against American Aggregates. So the judge correctly said, well, we don't apportion damages at this time.
You can't split damages.
No, at that time you couldn't. And he said, go back and you got to come back with one verdict. So they came back with the $750,000. Should we keep going about the story? Because it really doesn't end there.
Yeah, tell us.
Okay, so what happened there was the truck driver says, I'm going to pay. Okay, American Aggregate says, we're going to appeal because the jury said only $50,000. Now we're getting stuck for $375,000. So I said to the Allstate, who was the truck driver, I said, well, you're not just paying half. I said, I could lose my half on appeal. So if you're going to settle, you're going to pay 3/4 of the verdict and give me an assignment of your right to get contribution. If I win on appeal, I get 50%. If I lose on appeal, I end up with 75%.
Okay,
If I win on appeal. Okay,
So what
now I
happened?
got 125%. Okay. But that's only the beginning of the story. As great as that was, in the appeal, the Court of Appeals, in deciding whether or not they would apportion, put in a footnote. The footnote said, Justice Williams and Swainson, two Michigan Supreme Court justices, think the law should be changed from contributory negligence to comparative negligence.
And what that means is, right, so we got to explain this for people, is it used to be that if you, was it just 1% at fault, you lose?
1%, any percent at fault, you lost.
That's insane to
Yeah.
me. I
Yeah.
mean, so like we were talking earlier a couple weeks ago about, people who have a slip and fall. So if a jury finds that the injured person was even 1% at fault, so like could have done something this 1% differently, then they lose the whole case?
Right.
That's insane.
And we used to try cases like that, and we'd always be trembling. Oh, you got up for work. You were 20 minutes late. If you hadn't have gotten up
for work,
you wouldn't have been in this
because
accident, would you?
I mean, you can always say that somebody could have done something slightly differently, right?
And there are people who believe everything is predestined, and so if you were there, took a different street, or you got there earlier or later than you usually do, and they go back in the jury room and think, that's the way predestined, so you were at fault because you shouldn't
That's
have been there.
crazy, man.
Yeah, I mean,
that was hard. That was a hard rule.
Right.
So now it's different, though. Now it's everybody's responsible for their fault. So if I'm 10% at fault, you get 10% off.
Yeah,
right?
but if the Michigan changed it. The Michigan Supreme Court said even if you're 95% at fault, you get 5%. The legislature changed it to 50%.
Right.
If you're more than 50, you're going to lose.
But now it can be divided up, right? So like in that case, American Aggregates, the gravel pit, the jury could find they were 50,000 at fault, and then the other, the truck driver was the rest, right?
Right. Okay, but that footnote, I got another case that had already been ridiculous, should never have been filed, and I got it dumped on me, which is another story. If we had time, I'd tell you that story. But as a result of that footnote, I had an idea, and in another case that I'll come back and tell you about, I changed the law from contributory negligence to comparative negligence.
Which is what we have today.
Yeah. All because of that footnote in this case.
On your case. That you used on another case.
I never in 100 years would have thought about it. I never would have thought. I mean, I grew up with contributory negligence, and I assumed it was embedded in the law forever, and I never assumed that the Supreme Court could just change it. Maybe the legislature could change it. Who knew? I mean, it was part of my living.
You never thought, right.
Part of my living. And suddenly I saw that footnote and I said, well, I got nothing to lose. I got a case that I can't possibly win. It was dumped on me for some reasons. And,
because nobody else wanted to try the case, probably.
And my partner, who had lost it already and got it, and he came up, you're the only one in the office who could win it. Now,
and you did.
Now what am I going to do, John?
Let me ask you something, Sheld. What do you think, looking back, that has changed about the practice of law and being a lawyer?
God,
and is it
different?
for the best or for the worst, or both?
Well, there are no surprises now. There are no surprises. I grew up, I promise you, this is God's honest truth. When I grew up, the only experience I had with anybody in court was Perry Mason on television, black and white television.
Yeah.
And in every one of Perry Mason's case, the person he's defending isn't the one who's guilty. It's always somebody in the courtroom or somebody he brings in. It's always a surprise who the guilty person is.
Yeah.
I grew up with that, and I swear I had no experience at all. My father was a milkman. I had no idea about any of this. And so I thought that that's what happened. Now, I was trying just car damage cases, just starting off, no injuries, just. But I always thought somebody was going to come in. Honest to God, first 3 trials I had, I'd always be looking at the door for the surprise witness. Finally, I realized, that isn't how it happens. No, but then it was surprise because they didn't take, first of all, the rules were so different. If anybody, including the best doctor in the world, a neurosurgeon, whatever they are, nobody, they had to come to court if they were offices within or lived within 50 miles of the courtroom. No exceptions. No exceptions. They came in live. Sometimes you'd have a fabulous doctor waiting in the hallway for 2 hours while somebody's finishing with a witness that took longer than they wanted.
Yeah.
And that was crazy. Okay?
That doesn't happen that much.
No.
These doctors will not even come to court.
No.
They'll refuse. I've asked them. They'll say absolutely not.
Right. So they changed the rule now, well, a heck of a long time ago, that experts can be deposed under oath. You videotape them or just
show the video.
or even just read their transcript,
right.
Of course. So that part changed. Now, in the last 2 years, they've changed it again. Now it's even better than that, if you like. There are no surprises. We file a lawsuit. They file an answer. We have so many days to disclose every facet of our case in writing, give it to the other side. Every facet of the case. All the witnesses, all the damages, everything that's taking place. It's got to be in that statement. And if something changes, we have to notify them of the change. Then they tell us everything about that case. Now, that's to try and settle these cases. So, I mean, it makes sense. But, there are no surprises now, almost none.
What about the lawyers? Do you feel like the lawyers have gotten better, worse? Are they, the same? What's your feeling on that?
Well, because now there's so much discovery and you always know almost what everybody's going to say. It's a lot easier to settle the cases. Okay, maybe they go through a whole bunch of steps to get to that point. 95% of the cases settle. And that's probably the way, otherwise the system would break down if you had all those people going to trial.
Did they try more cases back in the day?
Everything was tried. Everything was tried. A little bragging. In 1971, I came up with the idea for the alternate dispute resolution. I came up with the idea. I called it mediation. They then called it case evaluation, in which I went to the Supreme Court by the chief judge of Wayne County. I came up with an idea. The backlog was 5 years. I had
5 years?
5 years.
So you file a lawsuit, you had to wait 5 years to get to court?
5 years.
That's insane.
There were no discussions. Nobody knew what the other side had. There weren't depositions. You just had medical reports and things. You never talked to the other side because nobody wanted to break the ice and give the first number. So I had already been appointed by American Arbitration. American Arbitration handled cases then of uninsured motorist claims. And that was a panel of 3 would decide those cases by the insurance policies. And they appointed me, American Arbitration appointed me to pick the plaintiff lawyers who sat in those panels. So I had the idea from that, it wasn't an original, that we could get a panel on these other cases and they could decide whether the case should settle or not. That way we'd break the ice. And I put in a penalty that if you turned it down, and you didn't better your position by more than 10%, you had to pay the other side's actual attorney fees. I understand you got $1,500 an hour on one of those cases for crying. I thought I was a big shot 15 years ago. I got $1,000 an hour.
Oh, that's pretty good. That's pretty good.
Anyway, yeah.
But it all depends on who you ask, right?
Yeah,
So.
well, no, but you are, John. You're entitled to it, if anybody is. In any event, so that idea had already come to me that was a way to get rid of cases. So, and the Supreme Court adopted it. The other thing they adopted, the rule was by law, you couldn't ask what the other side did. They didn't have to disclose how much their insurance coverage was on that case.
That is crazy.
And so when I was meeting with the Rule Committee of the Michigan Supreme Court, I said the only way anything will work is if we are allowed to find out how much the insurance coverage is. And they said, yeah, and they changed the rule.
Yeah, that was important because
and that was very important.
You can't, it's malpractice. And just so people understand, right? Like, let's say you have a client, like, let's say your case. Okay. So this little kid dies. Okay. That's a huge exposure case. Huge. I mean, it's horrible. You can't put a price on that life. In the old days, if the driver only had $50,000 of insurance, $10,000, they wouldn't even have to tell you.
Right.
That's crazy.
Right.
I mean, I refuse to make a demand on a case until they give me the insurance coverage limits. Like I've had adjusters tell me, no, we're not going to tell you. We're going to play secret with the insurance. I say, that's fine. I'm just going to sue you because
then they have to disclose. Now they have to disclose.
Because then you have to. Because I can't advise my client not knowing it. Because the bottom line is 99.99999% of the time, nobody's ever personally paying for the judgment unless you're like,
even though you don't sue the insurance company, you sue the driver of the vehicle or the owner and the driver.
Right.
But the insurance company's backing behind them, and you go to trial because you know how much the exposure is. And if they offer all the money in the policy, 99% of the time you take it.
Right. Yeah, that's the way the system. I can't imagine not having the insurance.
Of course, and that's another reason no cases were settling. I mean, it was crazy. And the Supreme Court agreed, and they changed the rules since 1971 that you could get the insurance coverage.
Well, thank you. Thank you, Shel.
It was my pleasure, really. And in the first year, the backlog went from 5 years to 3 years.
Yeah.
And eventually it went down to lawyers were complaining the trials were coming up so soon they wanted to get an adjournment because they weren't ready for trial. It was coming up so fast.
And I think we're at about like 2 years now, depending, 1.5. If it's real fast, 1. But you're about 2 years on a case.
But it depends because they want you to go to these other kinds of things. Actually, you could come up for trial a lot faster. Now they send you the case eval. Now they send you to facilitation. They won't let you go to trial unless you've gone through these other methods before coming to trial.
It's hard to get a trial date.
Yeah, it's hard to get a trial, especially with COVID. We didn't have trial dates for 2 years.
Right. Yeah, it's hard.
Yeah.
Well, hopefully we both have many more trials in us, Shel.
I hope so.
Hopefully we do. Well, thank you.
Someday we'll get it right.
Yeah, one day. Well, thank you for. The last thing is you didn't tell the Picasso story.
So the closing argument came. I told you about the other things. So again, I was thinking of how was I going to tell the jury the value of these kids? What could you say? In other cases, almost every other case, the plaintiffs come in and say, this is right at the opening. This is what we're looking for. I said, I'm not going to ever let anybody say that I said this child's life is worth some certain. It isn't. I'm not going to ever do it. Okay. So I came to that closing 2 minutes and I came up with this. I said, if on August 2nd, the day before this took place, the Sexton family was sitting around the dinner table. Somebody came to the door with a big package in their hand. And they said, Mr. and Mrs. Saxton, we have this valuable piece of something in this package. It's worth a lot of money, but we will give this to you. But tomorrow, when your kids are coming home from basketball practice, they'll be in a truck coming down, and the vehicle will smash into the truck, and they'll be killed. And every time at Christmas and Easter and every meal, you'll miss them blah, blah. I went through, a whole bunch of things as to what that loss meant. But here's what you'll get. This is a Picasso painting worth $3 million. And it depends. The one good thing about the Picasso is I watch the jurors to see if they're folding their arms like they're still not sure, or they're crying and they are sure. And the value of that painting goes up and down as I watch the jurors to see how the was going. And I say, and this Picasso is worth $3 million or million. Now, you've seen the Sexton family and you saw what their values were and you understand what was important to them. Is there any question in your mind that if they were offered that $3 million Picasso painting, they'd say, that's not fair.
Keep your painting.
That's not just. Ladies and gentlemen, what is fair and what is just is up to you. And I sit down.
That's a good way to end. That's a good way to end the show, too, Shel. Thanks a lot for coming on. You're the man. You're an OG. You're a legend.
What the hell does OG mean?
OG, baby. Our listeners know you're an OG. You're a G.
Is that a swear word?
All right, everybody. It's been another awesome episode of Cases Gone Wild. Thanks for joining in and being here with us today as we talked about some of these cases and some of the experiences that we've had. Please follow us, share with your friends. If you or a loved one need help, please don't hesitate to reach out. You can contact us, markolaw.com. That's www.markolaw.com. Or give us a call at 313-777-7LAW. We'll see you in 2 weeks for another Cases Gone Wild.